My apologies. Good evening to everyone. Thank you so much. This is the ULURP hearing at Brooklyn Borough Hall. Welcome to everyone. There is one item on the agenda this evening. Please note that this hearing is being recorded to comply with the Public Law for Transparency. It will be available for viewing on Borough President Adams' website, brooklyn-usa.org, or on the One Brooklyn channel on YouTube. Again, web viewers may submit timely comments to Ask Eric at brooklynbp.nyc.gov for Brooklyn Borough President Adams' consideration. I'd like to take a moment to just thank the staff, Director Richard Bayrak, as well as Ina Gusenfeld, Land Use Coordinator, and Joe Fizell for the recording of this particular evening. If you can call the calendar item, Ina.
Calendar item number 180095ZMK.
This application by Silver Shore Properties 97 LLC for a zoning map amendment to rezone from R6B, the portion of the block on the east side of Underhill Avenue, north of Dean Street, as an enlargement of the adjacent C2-4 district in the Prospect Heights neighborhood of Community District 8. Such actions would facilitate the conversion of the majority of a ground floor permitted parking area to commercial use at the corner of Dean Street and Washington Avenue. Community Board 8 will be voting on this application on December 14, 2017. Borough President Adams will hold off on making any decisions until he hears from the board. Would Frank St. Jacques, the representative for this application, please state your name for the record and present the application? Yes. Thank you so much, Frank.
Good evening. Frank St. Jacques, Sheldon Lobel, PC for the applicant. Thank you, Deputy Borough President Reyna. Sorry, is there a control for the slideshow? I apologize. Great. So we're presenting this project for the 35 Underhill Avenue rezoning. It's for a zoning map amendment to extend the R6A C24 to the west. Sorry, where am I pointing? Oh, towards. Is it possible to move the podium over slightly? Okay. Just give me a hand. Sure. I'll go through the first few slides relatively quickly. This is a zoning map, the official zoning map reflecting the zoning that exists on the site. If you'll move forward. And then the tax map outlining the proposed development site. The block is situated between Washington Avenue, Pacific Street, Underhill Avenue, and Dean Street in Community District 8 in Brooklyn. If you can move forward. Here's an area map that we'll come back to, but essentially it reflects the existing development patterns and use patterns in the area. Here, the development site is outlined in red, and you can see that there's an R6A mapped within 100 feet of Washington Avenue with a C24 overlay on that portion of the block, and an R6B on the remaining portion of the block to the west. If you could advance. There's a couple of pages of photographs of the site. The development site, 35 Underhill Avenue, the condo building that the applicant is seeking to develop is the yellowish building in these slides, if you'll advance. These are some of the adjacent properties. These brick buildings are at the corner of Underhill and Dean Street and would be included within the rezoning area. And then this is the site again. So if you'll advance slide and then just to the next slide. So as I mentioned, we're here seeking a zoning map amendment to change the existing R6B to R6A C24 on the portion of block 1131 that's fronts on Underhill Avenue and Dean Street. If you can move forward. Oops, thanks. And so this is the tax map again. It's a relatively uniquely shaped tax block with the development site being the largest of the tax lots. It's sort of a unique shape, and it spans the R6A and R6B districts mapped on the block. This tax map has been annotated to show the proposed rezoning with the R6A C24 mapped over the entirety of the block, essentially stretching the existing R6A C24 beyond 100 feet of Washington Avenue over the balance of the block that fronts Underhill Avenue and Dean Street, if you move forward. So again, the current zoning is reflected here on this zoning map, and what's permitted in the R6B, which is the current zoning, is a maximum residential FAR of 2.0. That R6B district was established in the 1994 Prospect Heights rezoning, as was the adjacent R6A C24, which has a maximum residential FAR of 3.0. If you can move forward. So here, again, is another illustration showing that this application would simply extend the R6A C24 over the entirety of the block. If you can move forward. Why are we here? There is an existing building on the development site that is essentially built full within the existing zoning, again, the split zoning R6A, C24, and R6B. And it only has an available balance of about 465 square feet of floor area. So no new development would be permitted within this building, including on the ground floor. The ground floor was developed as permitted parking area for 15 spaces, and it's not considered floor area. So about 5,100 square feet of the ground floor of the building fronting Washington Avenue and Dean Street, while commercial use is permitted in that space pursuant to the use provisions in the R6A C24, the building simply doesn't have enough floor area to accommodate a conversion to ground floor commercial use. So commercial use would be considered floor area. There's not sufficient floor area to convert the floor area. So if you move forward, this chart reflects the proposed floor area calculations. Were the R6A C24 to be extended over, it's approximately a 3,600 square foot portion of the development site that's currently within the R6B. So because of the split nature of the zoning on the development site, that portion which was restricted by a maximum FAR of 2.0, if that maximum FAR were raised to 3.0, it would unlock approximately 4,100 square feet, which could then be converted to a commercial use on the ground floor. So I'll walk through this is the existing site plan showing the building. It's in two segments. It's a condo building with accessory cellar parking for the 39 dwelling units, condo units on the upper floors. That cellar parking is accessed by a garage door on Underhill Avenue and a ramp. And it's a single building, but it's in two elements, a 4-story element on Underhill Avenue and a 6-story element on the corner of Dean and Washington, if you'll move forward. This is the existing ground floor plan. The yellow reflects the residential portion of the building on the ground floor. As you can see, there's dwelling units on the 4-story portion fronting Underhill. That gray strip below those residential units on the Underhill side is the ramp to the cellar accessory residential parking garage. And on the Washington Avenue Dean Street frontage, there's the building's lobby, some quality housing, residential recreation space, and the permitted parking area, that approximately 5,000 square feet, which is not considered floor area, which has historically been underused and not used for permitted parking. At this point, there's no active permitted parking use at that site. So if you move forward. This is the proposed ground floor plan. Essentially, the difference between these slides is that with the zoning map amendment requested, again, the portion of the block that's fronting Underhill would be remapped with an R6A rather than an R6B zoning district, freeing up approximately 4,100 square feet on the ground floor to develop what's contemplated currently as a grocery store. There would not be sufficient floor area unlocked by the zoning change to develop the entire ground floor. So the balance is proposed to be permitted accessory parking for the ground floor grocery store. So the area that's shaded in the pink color is the new commercial space, again, which is conforming currently, would remain conforming in with the zoning change. And this is just a illustrative layout of a potential grocery store use. So if you move forward. These are elevations of the building. Really, they wouldn't change much, but for the ground floor, which would be required to open up and provide sufficient entrances and signage for the ground floor commercial use. So you can move forward. Here's an illustrative rendering showing the Washington Avenue frontage with some signage and awnings and some additional glazing for a ground floor commercial use here at the supermarket. So go to the next slide. There's another rendering just at a different angle showing that a more active streetscape, which would be created by permitting ground floor commercial use at this site. And that's really, if you could move forward. These are just really facts that I'll go over these are some more detailed aspects of the specifics of the square footage. The lot itself is approximately 1,700 square feet. As I've discussed, it's a split lot between the R6A and the R6B. Approximately 3,600 square foot portion of the development site is in that R6B district. It's not subject to the split lot rule, which would allow that portion of the site to be developed pursuant to the R6A rather than the R6B. So it's the site as a whole is considered the portion which is within the R6A is subject to the R6A bulk provisions, and this portion that's within the R6B is subject to the R6B bulk provisions. You can move forward, please. Some additional details about the building. As I mentioned, it's a 4- and 6-story condo building with 39 units. The total floor area, residential floor area of the building is about 46,000 square feet, and it's a 3.0 FAR. It has 20 residential parking spaces in the cellar to meet the residential parking requirement for the 39 dwelling units, and the ground floor is developed with the 15 permitted parking spaces. Move forward. The Department of Buildings issued a final certificate of occupancy for the building in 2008, reflecting these uses, and that's consistent with how the building is being used today. So the rezoning action would not only affect the proposed development site, but two existing buildings on the corner of Dean and Underhill, The first 43 Underhill, Lot 1, is a 4-story apartment building. It's presently overbuilt in the R6A, and it would also be overbuilt in the, it's overbuilt in the R6B, and it would also be overbuilt in the R6A, which has a maximum FAR of 3.0. Similarly, if you could move forward, Lot 3 is also overbuilt in the R6B, in the R6B currently, and would be overbuilt in the R6A. So we're not anticipating development on either of those sites. The other lot, a portion of which is included in the proposed rezoning boundaries, is Lot 9 on the corner of Pacific and Underhill. It's unimproved, but it's being used as an accessory outdoor dining area for the adjacent ground floor restaurant. I believe on the adjacent lot, I believe is Lot 10. Those two sites are in common ownership. But because that's a split lot, the majority of which is in the R6A, it can be developed today pursuant to the R6A C24 zoning bulk provisions. So we brought this application to city planning and discussed the issue and what the applicant was trying to achieve, which is essentially developing the ground floor portion of this existing building on the corner of Washington and Dean with a new active ground floor commercial use. We did a study of the area of Washington Avenue in particular and found that commercial use is consistent with the zoning along Washington Avenue and consistent with the existing land use and development patterns along Washington Avenue. It's a relatively busy commercial corridor with mixed use development, essentially from, at least from the site down to the park. This zoning map amendment would benefit the community by facilitating this conversion. The applicant is contemplating a local grocery store, and we'll have a fuller discussion about that with the applicant and with your office. And what attracted city planning to this application and allowed us to proceed with the application was that this application would essentially serve to enliven what's essentially a dead corridor or a dead corner. It's a blank street wall currently, and the ability to develop a commercial use on this site would activate the corner and create a more lively pedestrian experience. In addition, it would also bring an existing non-conforming commercial use, that corner site at Dean and Underhill, into conformance with the use provisions of the zoning resolution. I believe, just skip forward. I believe that's my last slide. Then I'm happy to answer any specific questions.
Joe, I know you have to jump back to the camera. I want to see the map. That proposed ground, no, the proposed rezoning. The one that said, that's the current, and then the proposed. Mm-hmm. Thank you. Thank you, Frank. I just wanted to had a memory blank right there. I wanted to just ask, as far as your services to this application, were any of the other property owners adjacent to this property in question notified as far as this rezoning application?
We posted a notice. So the owners of the condo units within the building were notified.
Outside of?
So in advance of our initial land use committee hearing with CB8, we posted notice on the exterior of all the buildings with, I believe, on the whole block. It's a small block, but so all those notice, we posted a public notice with respect to the rezoning action and the then upcoming land use committee before Community Board 8.
So you are not aware whether or not there's confirmation with other property owners adjacent being impacted by this rezoning?
That was the extent of our outreach to the adjacent property owners.
But no contact, physical contact?
No.
Okay. I know that I wanted to take an opportunity to recognize Ethel Tyus, who's here from our community board, and she's the land use and housing chair. So I appreciate that you're present, and I know that the community board will be voting on the 14th, and you came for observation and trying to gather more information regarding this particular application in question. So we appreciate your presence, and I thought you were going to testify, which is why I didn't acknowledge you in the beginning, so my apologies. As the zoning boundary change would not enable all of the permitted parking floor area to be converted to zoning floor area, plans indicate a two-car 1,000 square foot permitted parking garage that does not align with the existing curb cut and with direct curb cut access blocked by a street tree. This permitted parking garage could be transformed to zoning floor area if the residential condominium property could be combined with available air rights or a zoning lot boundary adjustment that could be obtained from one or more adjacent neighbors on the north side of the block, enabling the retail space to grow another 1,000 square feet. Given that this strategy would resolve the tree curb cut issue and provide more flexibility for retail operation, what consideration has been given to pursuing such strategies with neighboring underbuilt properties?
So you're absolutely right, and I'll just give you a little background on how our office got involved in the project. When the applicant first approached our office, and even before I was working on the project, the first suggestion was not to go in for a zoning map amendment. It was to seek potential available development rights on the block and create a merged zoning lot in order to transfer unused development rights, allowing freeing up that of the ground floor space. So the applicant initially pursued just rather than opting for approaching city planning and undertaking the zoning map amendment application, actually approached the property owners fronting Pacific Street and also fronting Washington Avenue. So sites that would meet the conditions necessary to transfer development rights from a merged zoning lot. So lots 17 and 18 fronting Washington Avenue, and lots 9 and 10, which are in common ownership, and lot 11, the applicant made attempts, and I believe this is back in 2016, to contact those owners about a potential deal to essentially to buy unused development rights on those sites. Because you're absolutely right, there is available floor area or unused development rights based on the existing built structures on the lots to the north of the site and adjacent to the site on Washington Avenue. It's our understanding, based on publicly available information, that none of these lots on their own would have sufficient floor area to achieve the full 5,000 square feet of ground floor. Essentially, there wouldn't be, with a deal with one neighbor or one adjacent property, you wouldn't be able to obtain sufficient floor area to develop the whole ground floor. So it would require an aggregate, essentially an assemblage of multiple tax lots to come up with an aggregate square footage to achieve the full 5,000 square foot. Based on the applicant's unsuccessful attempts to go that route and to try and basically create an assemblage of development rights to forego a zoning map amendment application, we started our discussion with city planning. And our initial question to city planning was, would you consider entertaining an application for a higher zoning designation that would free up, essentially, a higher maximum FAR that would free up more floor area in order to develop the full ground floor with a commercial use rather than, having to allocate about 1,000 square feet for parking. City planning was not, there's some issues with that, consistency of a higher zoning designation with, what's mapped on Washington and the surrounding area. So we opted to, the applicant would ultimately like to be able to develop the full ground floor. So to your point, I think that, if this application were to be approved, the applicant would certainly reach out to all those property owners, and an ideal situation would be a full ground floor footprint with commercial. It's certainly a much more efficient space. It's a bigger space. It's a bigger rentable space, and would be able to potentially provide more, goods and services to the neighborhood. There's not a lot of uses there's really very few uses for that balance of 1,000 square feet. Permitted parking was really the only. It's not an ideal solution, but it's the one that is zoning compliant. So again, to answer your question, the applicant would certainly consider reaching out to adjacent property owners. They haven't had success previously, but may be able to, at this point, to basically free up an additional 1,000 square feet of floor area so as to avoid having to develop that portion of the site with permitted parking.
You continue, Richard. I just want clarity. So the same owner today for the commercial space is the same owner from 2016?
Yes.
And so this particular owner had you on as far as representing them in 2016?
Correct.
And so there were conversations with property owners then in 2016 concerning the...
Between the applicant and adjacent property owners, in specifically in the context of inquiries into whether those adjacent property owners would consider entering a deal to sell development rights.
Development rights or the property, because that's two different conversations.
Development rights is my understanding. The conversations were limited to
air rights.
Air rights.
Not property rights.
Correct. So not a sale of, lot 9 or whatever, but any unused development rights on that lot in order to, achieve additional floor area on the development site. That's my understanding of those conversations.
Which would have required, even if you had air rights, would have required what would be this rezoning, or the rezoning would not have been necessary?
So were the applicant able to be successful in that approach? Were those property owners willing to, in the aggregate, sell enough floor area? It would have, we would not be here. We would not have to seek a zoning map amendment to achieve the same ends. It seems, this is the ultimate goal here is to achieve ground floor commercial use on this site. We ruled out that approach as being possible, and then went to city planning as a second approach. With the same rationale too.
So again, rather than waiting to see the outcome of the ULURP, perhaps starting that conversation towards the 1,000 square feet with the multiple property owners may make sense now, and by the time you get to the council, perhaps you could report on the outcome of the conversation of whether 1,000 of air rights or zoning boundary adjustments, property adjustments to get, roughly 330 square feet of land transferred to this lot, you know, so to have a solution to not have that tree in front of the new entrance, perhaps you could have that potentially sketched out or resolved already by the time you get to the council, rather than simply waiting for the council to act.
Well, I'll discuss that with the applicant, and I don't think there'll be any issue with that.
As the application documents depict the intended use being a supermarket, what mechanisms would guarantee that the commercial condominium space is leased to a supermarket tenant, or what time commitment would be reserved to secure a supermarket? What duration of lease would the applicant be willing to offer a supermarket tenant? And clearly, because this isn't a supermarket requirements as far as space is concerned, it doesn't meet what would be the fresh zoning.
Right.
And so to say it's a supermarket tenant is far-fetched.
Understood. And sorry, that's maybe an error in nomenclature. There is no mechanism in place that would bind the applicant specifically to a supermarket. You know, this is a commercial space, and through our discussion with city planning and through the applicant's discussion with the condo board, so the condo board president is here and can speak directly to this, but there is an agreement in place that the condo board has discretionary approval or discretion to approve the ultimate tenant of the commercial space. One of the ideas and one of the commercial uses that they're most interested in, being that they're living directly above the commercial use, was a supermarket. The condo owners have identified that as a need in for the building residents and for the neighborhood generally, and thinks that with the right operator would not come with some of the same potential for nuisance that other commercial uses may carry. So to answer your question, there's not a mechanism in place other than a strong interest that was expressed by the condo board and the applicant's desire to find a commercial tenant that fits within what the condo board is looking to be the ultimate tenant. We do fall below the fresh threshold and as far as the square footage, so we simply couldn't qualify for the fresh program. My understanding is that the applicant is going to work with a commercial brokerage to find a tenant that's in line with and so I'm going to keep saying supermarket, but this is a small
Grocer.
supermarket. You know, it's about 4,000 square feet. You know, more akin to a neighborhood market where you go in and get basic things, but you're not pushing a cart around. The interest in is getting a tenant in that's the condo board is going to approve. So the plan is to work with a commercial brokerage to find potential tenants that can work within the space, can operate within the space. It's somewhat constrained with the size. So that's really the limitation on the commercial supermarket use, but it's something that has to be approved by the condo board.
In terms of securing the grocer tenant, what consideration has been given to securing a grocer with affordable pricing as a means to provide a benefit to the greater community?
So I think that's I don't know that the applicant has gotten that far specifically. I think that's something that they would certainly consider. I think the goal for the ultimate tenant is to find a tenant that's going to be successful and provide is going to be a good commercial tenant that's going to provide goods and services that the neighborhood wants and needs.
Is your firm supporting your client to speak to what would be the Small Business Services Department?
We're not involved in that, but I know that that's really the route that an applicant would take. We've certainly been part of other applications where applicants have sought the advice of SBS. So while we're not directly involved, we will certainly take the Borough President's advice on and ask the applicant to take your advice in that regard, and can guide them in seeking a tenant and working with SBS in doing so.
And as well as just accessing other incentives to keep what would be the commercial space affordable to accomplish the benefit of the greater community for access to what is the potential for a new grocer in the area. What is the expected frequency of truck deliveries? Where would loading take place? Dean Street versus Washington Avenue? And what steps would be taken to secure curbside loading signage?
So this is speculative. I mean, we're working with an illustrative floor plan, but in conversations with the applicant, the architect, and the condo board, we think Dean Street is probably a better access point for truck deliveries. Not sure of what the frequency would be. I think ultimately working with the operator on coming up with an operational plan that's so as not to disrupt the condo tenants above. Dean Street seems to be the most appropriate place for loading, and an application would be made to the Department of Transportation to ensure that there's adequate standing or loading space along Dean Street.
It's designed to look like commercial because corona cheating.
The original specs filed with the Department of Buildings, where was the presumed commercial space loading and unloading?
There was no commercial space in the
Original
in
filing.
the original filing. It was all permitted parking. So there's, I believe that parking was accessed from Dean Street, from the sort of close to where the store entrance is, shown on the ground floor plan.
And so the filings today reflect what would be a commercial space with loading and unloading?
There's no loading shown on but there's no loading required nor shown on this plan. This would, presumably be street loading.
It's too small, even if it was done legally to the trigger.
So our understanding is the threshold's about 2,500 square feet for a required loading dock.
Hence why it's not a supermarket.
Right, and our apologies. It's I think on our plans we say grocery store. So supermarket, I apologize, I'm conflating terms, but
No,
or it's
I don't
intended
wanna-
to be a small local market, based on the size.
I don't mean to weigh in on semantics, it's just, there's a big difference between securing what would be curbside loading signage
Mhm.
because it's required at a certain space associated to the commercial venue.
Mhm.
And so in this instance, the loading signage will not be required.
I'm not as familiar with the DOT regulations as I am with the zoning. My understanding is that I can tell you for certain that there is not a zoning loading requirement. I believe that there's an application that can be made to the Department of Transportation to put up signage to essentially reserve space for deliveries and loading from the street for smaller uses where either there isn't loading or loading isn't required. If we were able to, we're unfortunately not able to use that permitted parking area for loading, that my understanding is would be considered floor area accessory to the grocery store. So we have contemplated, and city planning really pushed us to try and come up with a better use of the balance, and really think about how to consider operationally commercial use on the ground floor. Without a specific tenant, this is speculative, but I think street loading from Dean Street seems the most appropriate.
And Dean Street is a one-way.
Correct.
And so if there's no loading and unloading signage, then there's a double parking.
Absolutely. So you're right. I mean, there's potential if the appropriate provisions aren't made for a supermarket or for a market to operate here and load and unload properly. It does have the potential to create issues. We opted for Dean Street respectively over Washington Avenue because there's it's a busier street and there's I believe a bus stop almost immediately in front of the building there. So I don't, maybe there's someone that's better at this than I am that can think of a more creative way to provide for loading and unloading, but I think that's a larger conversation with the DOT, and then based on the specific operator and their needs, how much loading they're going to have, if it's by box truck or a bigger truck or just someone with a van.
And your firm has not reached out formally to the Department of Transportation?
Not at this point, because we other than knowing that there's potentially a need for some signage to address loading, we can't specifically articulate what it is we need from DOT. So we understand that it's a call that's going to have to be made when there's a user in mind. Potentially during the build out of the space with a tenant, but it's not something that our office has done. My impression is it's just too far in advance to make those arrangements.
And to what extent does the selected use require approval from the condominium board? If such use were to be a bar or a restaurant, would the board have a say in whether such eating or drinking establishment could apply for a permit to operate a sidewalk cafe?
So I'm going to defer to the condo board president to answer the specific question, but there's an agreement between the applicant and the condo board association that's been articulated such that the condo board has approval. The
condo board exclusively, or the condo board along with the commercial condo owner?
So I can have them discuss specifics, but my understanding is that the commercial condo owner, the applicant, would bring a potential tenant to the condo board for approval before they could enter a lease with that potential tenant. I don't think that, my understanding is that they haven't specifically contemplated whether or not a sidewalk cafe permit, would be something that would also require condo approval. Based on my conversations with the condo board president, I presume that it is, but I can have him answer that specific question. I think that they're exercising as much control as they've agreed to in the agreement between the condo board association and the commercial condo owner, the applicant. And
so are you inviting the condo owner now? Or
I'm happy they're here and they're available to answer questions if you would like them to step up.
So I'm going to move into the section of what would be our first speaker, and this is Sina Ganzari, condo board president at 630 Washington Avenue. Hi.
I come up here?
Yeah, come on up.
Okay.
This is your house.
Hello.
Hello.
This is great. Well, we're very excited about the supermarket. I'm just kidding. I know it's not a market, grocery store. So I'm happy to answer any questions. We have been really actually pleased with the working relationship that we've developed with the applicant to approve any sort of tenant that comes in. I think one of the things that we're acutely aware, I've been in the building, I live there with my wife currently. One of the things that we've been acutely aware of since I've moved in 2007 even, was that we're a new development and we want to be integrated to the community and be a part of the community. And there's a lot of new developments in the neighborhood, and there's also a lot of families that have been there for multiple generations. So being a part of our neighborhood and integrating properly and not and being quiet in a certain way, right? We view that highly. We have a lot of young families that live in our building. There is a bar across the street that operates events on the long weekends, and we've been really supportive of their work because it's not a heavily trafficked street, and they're young entrepreneurs that are trying to do something. So that's just at least a quick intro about kind of our point of view as a condo board. Any sort of bar or restaurant would probably be a little bit more difficult for us to look into simply because we have a lot of young families, and I think we have some quiet hours that are part that we try to enforce gently in our building. So that's something that we take under strong consideration.
As part of your negotiations with the commercial condo owner, is it a commercial condo owner?
Yes, they'll be paying, they pay common charges and stuff, yeah.
And so they would be coming to the full board, the executive board, to receive permission, and they would recuse themselves? Does the commercial condo owner have a seat on the board?
I see. Yeah, no, they do not.
Okay. And does the commercial condo owner only move forward on the tenancy based on what they present to you?
I think they would present, and we haven't formally discussed this in so much detail. It's at board discussions for us have been, they'll bring us a tenant and we'll go through our approval process.
Mm-hmm. And so if there is, let's hypothetically place a restaurant, the restaurant applies for a sidewalk cafe, because you've approved what would be the restaurant, is the sidewalk cafe part of what is an extension of the restaurant presumed to be approved?
I would say no. Just how our board would operate, I think we would probably take into consideration any approvals would come with conditions, or if the condition was okay, if you're going to have a restaurant, any sort of expansion of the restaurant into the sidewalk would need further approval.
And I don't know if you have any further comments.
Oh, yeah, we've been represented by counsel in all of our for the contract of sale, and so we always, communicate with them in any sort of official capacity when we're talking.
I would hope you do.
Yeah, of course.
Okay.
Thank you.
Thank you. Oh, if you could come back, Mr. Gazari.
Okay, just a quick question. Is the residential condo board entitled to any portion of the rent for what would be the food store?
No, just common charges.
Just common charges. Thank you.
Thank you.
So at this time, seeing no other individual, seeing no other individual who's going to be testifying, I'd like to just thank everyone for being here. Richard is going to a game with his son, so we hope the team wins. We want to make sure that any comments for this segment of this particular ULURP application is sent to Brooklyn Borough Hall, attention to the Borough President. This item is now officially closed, and we will review the applications the application we heard today, and will soon submit his recommendations to the City Planning Commission upon receiving what would be complete communications from the Community Board. Brooklyn Borough President Adams would like to take this opportunity to remind the public that the City Planning Commission will hold a public hearing on these items as well. This hearing is now adjourned, and please remember to view what would be on the website. Timely comments can be submitted by email to askeric@brooklynbp.gov. Happy holidays. There you go.